Welcome everybody to COVID-19 and employment law issues with our employment gurus, Beth Mora and James Wu. I'm going to turn it over to them because I know they have a full plate of information for us. So I guess what they want to do too is if you have questions, just put it in the chat and they'll break in as appropriate with your questions. So thank you, Beth. Thank you, James. And I guess I'll turn it over to James.
Thanks, Anne. So thank you, everyone, for attending in this webinar. We have a lot to get through, but we also know that there are folks on this call who are very experienced employment attorneys. So feel free to, I know it's not easy on this format, but feel free to type in the chat box if you had additional comments or bits of advice that you're giving or questions. We also know that there's some folks on here who don't really know much about employment law, so we're trying to balance that as well. You can see on the screen what we're hoping to get through today. Some of this, again, may be quite rudimentary for some, but for others, it's very important. We tried to tailor this so that it would be beneficial to both you as an individual, in case you may know either yourself or you may know someone who is being furloughed or laid off or is self-employed and doesn't quite know what benefits you may be entitled to, but also for folks who may be managing their own firm with respect to their employees and whether there are, and how to do a layoff or those kinds of things as well, and how to apply the new laws. So we have an ambitious agenda, so I'll hop right in. We may not cover everything on the slides, but we did try to make our slides much more comprehensive so that you can see some of the best practices and topics we've selected for you today. So we're going to do a quick run through. Obviously, the economy has slowed for many employers, especially those that are non-essential, as defined by the shelter-in-place orders. And so employers are trying to figure out how they can manage so as not to shut down completely. And so there are several different strategies that we'll briefly go through. One is a reduction in pay, meaning, frankly, employers can reduce the pay of their employees. There are some general rules for non-exempt employees. Of course, they can be reduced. Those hourly wages can be reduced. Obviously, you don't want to go below the minimum wage of either the state or if there's a city that your worker is in that's higher than the state. You want to be cognizant of that. Exempt employees, yes, they also can receive a wage reduction. For example, 15% reduction in salary. And some things to note there is similar to the minimum wage, you also don't want to go below the salary basis test regarding the exemption. Otherwise, you could lose that exemption. So these are just very basic ideas that we'll expand on here. You don't want to make these retroactive. In other words, for work that's already done, you can't say, oh, by the way, everything from April 1st to today is at a lower reduced rate. You can't do that. You can make it proactive, so everything starting tomorrow through, whenever we're out of this pandemic, you'll be at a different wage rate. Especially for non-exempt employees, you need to give written notice. The best form, which obviously is the most compliant, will be to use the Wage Theft Prevention Act form from the Labor Commissioner's office, but it doesn't have to be that form. Obviously it can be, and that's an easy way to do it. For your exempt employees, it's good to give them written notice as well, but you don't have to specifically use that form. Just be sure before you do any across-the-board wage reductions, make sure to review employment agreements. There might be some folks out there that have employment agreements that have, processes or contractual limitations as to when and reductions in pay can be done. And of course, you may have an employee handbook or other policy that may be involved, so you want to look at that as well. So if it's a more severe cutback, if you will, There are another possible avenue is furloughs, and for full week furloughs, they are permissible, but obviously if you are an exempt or have exempt employees, they are must be paid for their full salary for any work that is performed in that week. You can have partial week furloughs as well. You can also have sort of rotating furloughs. So maybe, half of your population is furloughed this week, but they do some work next week while the other half is furloughed next week. And then it just rotates, or maybe in 2-week increments. You can certainly do that as well. And I see from some of the comments, both wage reductions, furloughs, and layoffs will impact whether these employers may be able to receive full forgiveness for any PPP loan that they might have applied for and received, which we're not necessarily going to delve into the PPP loan this week because that was discussed very well last week in a prior webinar by Jen Lee and Margaret Schopp. So we won't get into that unless you guys really want to, but that's not part of today's discussion. The thing about changing salaries really for exempt employees or furloughs for that matter is you don't want to change them frequently. Otherwise it starts to look like they're an hourly employee and they may lose that exemption, which might not be the biggest concern at this point. I certainly recognize that, but it is certainly a concern to weigh as well. Layoffs obviously are a bit more severe. They're meant to be, people use the terms furloughs and layoffs almost to mean the same thing. The main difference, at least conceptually, is that a layoff is much like a termination, and you may be recalled, but a furlough, often people say, well, I'm on an unpaid leave of some sort, or administrative leave is like a furlough. Layoffs are more termination-like. Both, if a furlough or a layoff, well, certainly a layoff, you need to provide the final paycheck and the payout of the vacation/PTO, just like any other termination. You don't have to worry about the CalWARN necessarily at this point. Governor Newsom has relaxed that. And the federal WARN may come into play, but likely doesn't impact us here because layoffs need to be at least or more than 6 months in length for federal WARN. And also the size of firms in Contra Costa County, unless you're working at, for example, Littler or some other larger firms, you're probably not going to fall under the Federal WARN Act. So I think most people attending this webinar would not be impacted by the WARN Act. Let me stop there. I don't see any other questions.
There is a question from Kristen Barante. I have consultants telling employers who are adamant about converting exempt employees to hourly. I'm not fully following this question. I have consultants telling employers who are adamant about converting exempt employees to hourly.
Yeah, so I think I understand. And Kristen, so that is definitely something that's possible. There are some certain clients of mine even who are doing that, and I think mainly those folks are doing it because they can't or they don't want to meet the salary basis test for these folks who aren't performing a whole lot of work right now, so they're transitioning to making them non-exempt. And I think if that's your sole reason, then that's okay, and when this is all over, it'll likely be really pretty easy to get them back up to their salary and back to be exempt. I think if you're changing their duties and that kind of thing as well, then you're obviously going to have a more difficult or more burdensome road back to getting them to be exempt. You got to change their duties again and that kind of thing so that they pass both the duties and salary tests. I don't know, Beth, if you have other thoughts on that.
No. I know as a plaintiff's attorney, I'll watch it to see what happens.
All right, Beth.
Okay, so this information is presented to you as attorneys in case you get phone calls for individuals, for yourself, and also for your clients. The unemployment in California, we will also talk about the CARES Act and how that affects it. But this is just the basic California unemployment insurance managed through EDD that we'll refer to as UI or EDD. And it is for layoffs or reductions of hours for full or part-time wage replacement up to 26 weeks. And it can be up to $450. And the governor early on in the shelter in place waived the 1 week delay. And I'm sure you've all seen that before. What I put here also is tips for applying the system is very impacted. So information that people should have with them when they apply, and also information of suggested steps to take to try to get you quickly through the process. So those are information you want to make sure to have in front of you. Information also that you want to know about the process. People ask you questions of what's been going on in the last 4 weeks, previous from starting. This data is out from April 4th back. California has processed 2.3 million unemployment insurance claims, which is more than they processed in all of 2019. From April 4th, that week of April 4th, they processed almost 1 million claims, which is a 2,400% increase from the same week the year prior. Because of the impact on EDD, they are open 7 days a week, 6 a.m. to 8 p.m., and they're going to be opening a call center with similar hours, 7 days a week. They've pulled over 600 employees from other areas within the government in their training, and they are hiring. So if you know people that are looking for work, EDD is one of the few places hiring. One of the areas that we know is also impacted is the legal community. You get daily emails 2 to 3 times a day from Law 360 notifying of layoffs, reductions in force, reductions in salary. On April 2nd, Above the Law began a firm tracker. I understand that Contra Costa County doesn't have a lot of these large firms, but we do have some. It is important to keep an eye on these things. It will impact things across the board. The firm tracker started on April 2nd, already has over 50 firms tracking the reductions in force, compensation, and layoffs.
So Beth, we have a question, or actually, well, let's start with a question. Andrea has asked, if an employee files for unemployment, does the employer's EDD cost increase?
That's a really common question. So when employers pay payroll taxes, it comes from that fund. Employers and employees, every time they do their payroll, it comes from that tax and that fund. You would have to pay a significant amount of unemployment for it to drain that fund. But the other thing that's happened in this crisis is the government, through executive orders and through legislation, state and federal, has extra funded unemployment that will not tax employers. There's also been, which was covered last week, for example, in the presentation, there's been tax write-offs and exemptions and so forth. So yes, there will be some impact on employers in the sense that yes, if employees apply for unemployment, that traditional pull from the fund, attached to the employee, attached to the employer, but there's been lots of money put into the funds from the government. There's been lots of tax offsetting and state and federal government. So the goal has been not to, in essence, punish employers while helping employees pay the bills.
Great, thank you. And I note that Marta has provided that on the EDD portal, there's no need to say that it's a disaster area, that you can select COVID-19 as a reason for layoff, and there's no other, and say there's no question of a disaster. Apparently she's done it and it works. So just wanted to share that with the group. Thank you, Marta. Hope I summarized that as well. Okay. All right.
So under the Federal Coronavirus Aid, Relief, and Economic Security CARES Act, there is a lot that is important that was created out of the federal government for what I would think attorneys and also questions you'll be getting. This was put into place on April 1st. It was effective that day, but the instructions for the state that the state got how to implement it didn't really come out till the 5th. And the Secretary of Labor has been working closely with EDD to try to implement this program. They're trying to make sure it is launched within days, and they're really trying to clarify it. What here is happening is emergency unemployment benefits for workers that are left out of our traditional California unemployment or every state's unemployment, or they've exhausted that unemployment. So here what's important is that it expands for the group of employees that includes self-employed workers, independent contractors, freelancers, workers seeking part-time work, and workers who did not have a sufficient history to create a bucket of monies in their unemployment. This will be a benefit that runs from January 27th, 2020 through December 31st, 2020. And why that's important is that is a retroactive benefit. That's funding that happened before the act was even signed, before it came into effect, and even before people apply. So they're going to get kind of a lump sum. Also, you can currently apply for it through EDD, but effective January 28th, the Secretary of Labor has confirmed that they'll have their own separate portal for this. And then once you apply, it should be funded within 24 to 48 hours, not the 21 days that is traditional for unemployment. Are there questions that are coming up already?
So there's a question from an attendee, Janice. For exempt employees who apply for EDD because they have received a reduction in wage, how will their partial wage replacement by the EDD be calculated?
Do you mean exempt as in AB5, whether or not they were misclassified?
No, I think it's higher paid. It says higher paid employees. Maybe she didn't use the word exempt. That was my word. So I'll just read the question. How does partial wage reduction affect those higher paid employees if they apply for EDD? Will the eligibility for payment be based on total income to be paid on reduced half schedule?
And are you talking about, I think Janice is talking about EDD for California EDD unemployment, you can apply for reduction in compensation, the loss of income. And the PUA also says this is for people seeking part-time work. So in those situations, I would suggest until they have clarity, you apply for both. Try. They have not clarified the differences yet. Unfortunately, the separate application process for PUA, the Federal CARES Act separate benefit, isn't set up yet. It won't be set up until April 28th. So it is encouraged that you apply through the EDD UI system. So in both situations, you can apply for the partial loss.
Great, thank you. And I think the calculation of how much they might receive is the delta between what they were earning in the last, is it what, 90 days or 6 months? I forget the time period, but versus what they now are earning.
Yeah, and to be fair, even the Department of the Department of Labor Secretary said in a statement on the 14th of April, we are still learning the guidelines. We are still working on clarifying. She holds Facebook Live question and answers. She issues statements regularly. They are really trying to figure this out, and they will keep clarifying on a daily basis.
Yes, definitely evolving area. Here's some more information, Beth.
Right. So the benefit is an additional $600 per week. And that is an additional 13 weeks on top of the UI benefit. So that will extend the UI benefit from 26 weeks to 39 weeks. The CARES Act expires December 31st, 2020, unless the government extends it. I've given you the links to the most recent press releases from the governor and from the labor secretary that help clarify their current understanding of how the PUA and PUC, the CARES Act, interlink with UI. I do believe they will keep clarifying.
All right.
I want to remind attorneys, this is something that will come up not only for you, but your clients, that AB5 went into effect January 1st. There are lots of attorneys that are independent contractors and self-employed individuals under the CARES Act, that is for you. But also, you should still look at AB 5 to see if you as attorneys may qualify for California unemployment insurance benefits. Go to this section on the links we've given you here. There's a website that kind of walks you through whether or not you are classified or misclassified. This is for you, your clients, and then see if you will qualify for benefits in California as well as the CARE Act. It's a very complex walking process that James and I talked about in our January presentation of new laws in California. If you do not have that presentation or you were not present for that, please do ask us about it. It is really complex and definitely not something we can go through here, but it is something that's important. Did I cover that well, James, for you?
Yeah, that's great.
Okay, so some of the ways that people may find themselves out of work in this day and age and looking for compensation is state disability insurance. I know a lot of you have already gone through this already, so I'm not going to go over detail in this slide. What is important here is that it's for someone who's unable to work due to medical quarantine or illness related to COVID-19. SDI, that is the arm of unemployment, EDD, state disability insurance, has confirmed this includes people who cannot work due to having or being exposed to COVID-19. That is a very recent clarification. Please do look this up if you have further questions or let me know. Paid family leave is also another manner in which people may be out of work and looking for compensation during COVID-19 is when you are unable to work when you're caring for an ill or quarantined family member with COVID-19. It needs to be certified by a medical professional. Now, keep in mind, a lot of these certification requirements are getting a bit of a support by the governor with relaxation. A lot of the agencies are saying, be understanding. It can take a little bit of time to get certification.
Yeah, and I'll actually just point out, and maybe some of you have seen, I saw a report, I guess, from the FBI of all organizations telling employers or business leaders that apparently some employees, none, of course, advised by any Contra Costa County attorney, but some employees are submitting forgeries of medical documents saying that they have COVID-19, for example, because they want to be able to get some of these entitlements or these income replacement methods. So what the FBI is advising is that when an employer receives a doctor's note, obviously examine it. You're not required to be an expert on whether it's a forgery or not. But the FBI says that we can call the medical provider just to confirm that they sent the note. And maybe even the contents. I don't think the EEOC or the DFEH have opined about that, but that's what the FBI is recommending. So,
which fascinating as a plaintiff's attorney. If I heard that the employer did that for one employee but not others, or did it at all, I would immediately flag it and have serious concerns.
Right, I agree. If you do it for any just one, you should do it for all, frankly.
Which, by the way, I don't think they should do it at all.
Right.
Just saying, especially because, and this is something you'll see later, because the DFEH has actually said in a statement, I've given you the link, that they're encouraging employers in the reasonable accommodation process and leave process to allow the employee to get the documentation, give them the accommodation, even if the documentation may be late and may be forthcoming at a later time, because they understand in this world of telecare that on a video a doctor may do something, but it may take weeks to get the note because everything is slower now, that you may have a situation where the note's faxed to the workplace, but no one's at the workplace to get it. I mean, there's just these different ways that things are happening, and they're encouraging employers to accommodate with caution and with patience. So at the same time, being suspicious could be contrary to the very nature of what we're trying to do. And so being suspicious in general of everyone is contrary. So, and that's contrary to the governor's executive order on this very issue. So as plaintiffs, so this is one thing that's happening in very split thing between the two sides of the bench, so to speak.
Yeah, absolutely.
but we'll get along as we debate it. Paid sick leave, and I know you all have seen this, that there's the California Healthy Workplaces, Healthy Families Act with the 3 days of paid sick leave, which can be used in this situation for you or your family member who are sick for preventative care when there's a recommended quarantine. So that is obviously what's happening here. And please keep in mind that different cities and counties have broader scoped sick leaves, and that includes San Francisco and Oakland. Well, one of the things that we're seeing a lot of questions about is my child, their school's closed. And none of these other areas apply to me. What am I gonna do? I need to be at home. Can I get wage replacement? That was something the EDD didn't necessarily have an answer for. If you go to their Q&A, it is very clear that they're doing it on a case-by-case basis. So we are instructing people, apply anyway. Tell them this is a shelter in place, their school is closed, I have no child care. The younger the child is, we are seeing things being granted. Don't forget though, of course, there's California Labor Code kin care rights, and employers cannot retaliate against you for using that right. But for people who are trying to get paid leave through EDD, we are instructing people, give it a try. Another area we're seeing lots of questions is if someone is 65 and older. The CDC has said, and everyone says, stay at home, you're more susceptible. And then those very people are then questioning, well, do I get compensation if my employer isn't going to pay me, or I can't be accommodated by working from home? And that's a fantastic question. Unfortunately, the EDD, UI, and SDI, that's unemployment and disability, have not actually said that someone who's 65 years or older will qualify for benefits. They have said under unemployment that that's going to be a case-by-case basis. On SDI, there is no actual code for age. That doesn't necessarily make someone disabled, even under the CDC pandemic, to qualify for benefits. However, there has been discussion amongst doctors that the code R54, not a doctor, so obviously, that age-related physical debility may actually meet the standards for an application for state disability insurance. So several people have tried it, and again, it's being state by person by person. The traditional disabilities are diabetes, heart condition, things like that, but these are what is happening right now. I had a 65 plus receive EDD. Sweet, good to hear. Additional wage replacement options, obviously workers' comp. Someone who is unable to work because they were exposed to COVID-19 during their regular course of business. For example, someone who a district attorney or someone who got sick meeting someone in the jail or actually going to a hearing, which I'm hearing there are still some people doing hearings in even Contra Costa County. Just this last week, I heard of several. So you could be exposed, and that could be a workers' comp claim. There could be compensation replacement for that. Private benefits, of course, that you may have or your employer may have, such as short-term disability, long-term disability, a spouse's private benefits, and so forth. And then there's a great deal of resources here sprinkled throughout of how to look for compensation and benefits. One of the most common to look at is this chart link, and within this chart, it actually links you in the government to their application processes.
And speaking of resources, if you haven't checked out the Bar Association's COVID-19 resources page, please do. They not only apply to firms and individual attorneys, but all sorts of other issues as well, including how we practice with local court rules and everything else. So there is a great warehouse of information there.
Yes, Marta, we're going to get to, James is going to cover the FFCRA and those overlaps. So good point. One of the things we're seeing lots of questions on are when people are being laid off, they're being furloughed, they are very scared about their health insurance, and that is a very understandable concern. One thing to keep in mind is that Governor Newsom has ordered all COVID treatment covered. So please do keep in mind that, and also talk to your health insurance about any concerns you have. Premiums are being adjusted, so I've given you links to talk to your insurance. But obviously you have federal COBRA and Cal COBRA rights. Covered California, who is our basket for how we can get benefits if you've lost your benefits through your employer, is opening their enrollment and making it a broader time frame. I also encourage everyone to look at 211 or 211.org. In Contra Costa County, we have an extremely broad medical coverage for our residents as well. So there are wonderful options, and they have been open because of the COVID-19 situation.
All right, so Beth did a great job with state-provided income replacement. We're going to now turn to, I'm sorry?
That's very nice.
Oh, so here's the new federal FFCRA, the Family First Coronavirus Response Act, and it's already in effect. Went in effect April 1st. It's supposed to sunset December 31st of this year. It applies to employers with less than 500, so that's pretty much every law firm in our county, except for, you know, like the Littlers and the mega firms. And it provides some income replacement for COVID-19. I think at first when people heard about this, employers in particular were a little bit nervous that it would be a very onerous burden, if you will, to pay out all sorts of benefits to employees who couldn't work. But if you dive deeper into it, it's actually not as severe as you might think in terms of impact on employers, but it is a good balance with respect to providing income replacement for those who need it in certain situations. The Department of Labor has a great website as well. If you haven't checked it out yet, please do. There's a bunch of FAQs that they've actually done. They've been more proactive on this than most things they are proactive on. And they've even opined that, you know, we should let employers figure this out. So have some patience. And they had a grace period that expires tomorrow, in fact, for temporary non-enforcement as long as employers tried to act in good faith to comply. They also provided a notice that employers must provide to all employees. It's one of those other posters that should be posted where other posters are posted. And if your employees or if you are, you know, folks in your firm are working remotely, you should email that notice out to everyone as well. Again, you may receive payroll tax credit for wages paid under this. We won't necessarily dive into that today since it was discussed previously. But essentially there's two types. So we'll first start with the expanded family and medical leave. It's a little bit deceiving. It's only, your employees are only eligible for EFMLA, we'll call it, for one reason. That is if their child's school is closed or their regular child care provider is unavailable due to the coronavirus. So that's the only reason that someone might be able to get this expanded family medical leave. To be eligible for that, the employee must have worked at least 30 days. So you don't use the same eligibility requirements under all the other FMLA reasons that you're all aware of already that are in existence. The first 10 days of this 12-week entitlement are unpaid. However, the employee can elect to use their own personal accrued vacation, personal paid sick that Beth described. They can also apply they can use their expanded paid sick leave, which we'll talk about in a minute. And the other wage replacement opportunities that Beth mentioned. The rest of the time after the 10-day period is paid out at a regular, at the highest of either 2/3 of the regular rate or up to $200 per day. And again, for that shortfall of that perhaps 1/3 of pay, you could apply for state compensation, like the paid family leave and those kinds of things that may apply, and the state agencies may make up that delta. employers are supposed to restore these folks back to their employment once they exhaust their benefit. And there is an exception for a lot of our membership here in the Bay Area in Contra Costa. This might be important, that there's an exception to providing this for employers with fewer or 50 or fewer employees, and that's nothing you need to send in to the Department of Labor or anything like that. It's really an authorized officer of the business must analyze whether this really would jeopardize the existence of the business, and you have to confirm that and certify that, or the officer does. And there's no magic to it that has been provided, although the FAQs that I mentioned previously do provide what the criteria, or at least some of the criteria, are. So definitely check that out if that's an avenue your firm or your office is considering. So the expanded paid sick leave is your employees or you may be eligible to take that for one of these 6 reasons or a combination of them. I've highlighted reason 5 because it is the same reason as the expanded FMLA that we just talked about. So there is that overlap. But otherwise, these other items, which are numbered 1 through 4 and then number 6, that's the way the Department of Labor numbered it. I think if they thought about it more, maybe they would have put number 5 as number 6 instead, since it is sort of a sore thumb sticking out there. But in any event, it's really essentially if someone's sick. So either you, the employee, is sick, or you're caring for someone who's sick, and not just sick, but with COVID-19, or experiencing symptoms of COVID-19 and seeking a medical diagnosis. And that's pretty important, I think, for that one. This is number 3. If someone just has a sore throat and they might think that they have the virus, but they're not seeking a medical diagnosis, they probably are not qualified for this paid family leave because they're not seeking a medical diagnosis. They may just be taking self-care and staying at home or whatever, but they may not qualify for this wage replacement. So that's important to know. And then the amount of wage replacement depends on the reason, as you can see at the bottom of the slide. Those are the maximums for depending on the reason that the leave is taken or used. I know I'm cramming a lot of information here, but we wanted to be sure to get through a lot of it. So how do you figure out what it is? So full-time employees are entitled to 2 weeks. This is paid sick leave, 2 weeks, up to 80 hours basically. And part-time employees are entitled to their typical number of hours they work in a 2-week period. You cannot require employees to use their own other leave entitlements. It can be, the employee can certainly voluntarily use them. So in a, sort of in a long case scenario, if you will, they could use, let's say, 2 weeks of their own vacation and their own employer provided paid sick leave. Then they could use, especially if it's for childcare purposes, they could use their 2 weeks of paid sick leave, expanded paid sick leave, and then they could have 10 more weeks of the expanded family medical leave to care for their child who is home because their school is closed. So it could last 14 weeks really, or more in certain situations. So the law, the DOL has also clarified a little bit more what information the employee should provide to their employer. We talked a little bit about this earlier, but medical certification, my firm and I, we've created forms for employees, like an election form. If they, they check mark which leave the employee is seeking for which reason, and then depending on the reason, they provide like the school information or the doctor information, or the required information, as well as if it's a doctor's note they need, they provide that. Now it is as Beth mentioned, there is some leniency to that because, especially in certain areas, healthcare providers are not necessarily responding as quickly as they might for this. with respect to providing doctor's notes.
James, Chris Mead
Yes.
asked if there's any information on coordination between eFamily and CFRA leave. Is the CalLeg going to provide parallel eCFRA leave?
I don't know. I haven't heard that they are. There are two, last time I looked, there are two pending pieces of legislation that are winding its way through the California legislature. I just don't recall if it has to do with expanding CFRA to cover this.
So I
yeah,
know that the plaintiff employment groups and the family coalition groups and so forth have put in a request to have a parallel language, probably even more expansive language would be my reading of it, but it hasn't been signed off on yet. And it would come more along the lines of executive order piecemealing and legislature, because technically the legislature is still closed.
Yeah. And I think that there are some cities, I think like San Francisco, maybe San Jose, I think, and I briefly read an article that some cities are also putting sort of a expanded sick leave provision, but I don't have the details of that. That was just a very recent development.
But yeah, Chris, I think you'll see that there will be some legislative amendments. But the legislative calendar too is likely to be shifting again the longer the shelter in place remains. One concern is that you get 12 weeks of eFamily leave and then COVID-19 and get another 12 weeks of leave. Yes, you're right, the parallels don't match. And so the concern is making sure that we have consistent protections. And then on top of that, Chris, you're correct, at the same time, you don't have the agencies statute of limitations stayed, you don't have them with parallel rights, and the court's closed. So there's all sorts of issues that they're trying to make parallel right now. So all of those they're working on. So.
Yeah, and just I don't think all the attendees can see Chris's comment. So let me just explain that a little bit more. So Chris is pointing out a good point, which the CFRA has not quite matched, or the California legislature hasn't quite matched the federal new law. So it is possible for an employee, to take up to 12 weeks of this expanded FMLA, again, because of school closure or childcare issues. And then after that 12 weeks has been exhausted, they could still take up to 12 weeks under CFRA for all those other CFRA protected reasons, so maybe they need to have surgery, or they have, other CFRA reasons. They could have another 12 weeks for those reasons. So it could be, if they're eligible for both types of leave, yes, it could be 14 weeks of leave. So unless something changes in the legislature. Sorry, I think I said 14. I meant 24 total. I do know how to add. So, all right. So here are some common questions that I've been getting, and there's been a lot more, and I'm sure there's other folks on this webinar with great employment experience that have experienced some as well. But so employees, if they're just afraid to come back to work because they don't want to contact the virus, or maybe they're a salesperson and they don't want to go meet potential clients in person, that's not a qualifying reason. Fear of getting sick isn't a qualifying reason. I think that's pretty clear. Folks who were furloughed or laid off prior to April 1st, remember the FFCRA became effective on April 1st. So folks who were furloughed before April 1st are not eligible for any of these new FFCRA leave entitlements. If you've been, or if you know someone who's been furloughed or laid off after April 1st, for example, if they get laid off today, if they were eligible for any of these leaves prior to today, they could have used it for that period. But once today they're laid off, then no, they're no longer eligible for the entitlements. Yes, employers can definitely provide more sick or more PTO or more vacation. I've had several clients who are updating either to provide more, or unfortunately to cancel it, to take it out of their handbooks and not provide vacation once people return to work because they're afraid of the economic hit that that'll cause down the road. So yes, employers can certainly adjust their vacation policies, either up or down. Obviously, the paid sick leave, you don't want to go down or eliminate it completely, because then you might be in violation of California law on that. And those changes should be only done proactively. Employers can also suspend or alter attendance policies to reflect the new reality of people, again, not being able to get doctor's notes quite as easily as before. And again, the flexibility needed there. So employees who are working remotely, teleworking, are still eligible for these types of leaves. And they could be entitled to intermittent leave as well. So let's say they can work part of their day, but then can't work the other half because they do have to take care of someone who's sick or because they have a child at home. Intermittent leave is okay. But if they're working at a normal work site, so right now that really only would be essential businesses that are open, or at least that's the way it should be, then you can't work intermittently. You have to take the whole day off. And the reasoning there, unless it's for childcare reasons, and the reasoning that there is because you don't want someone who's taking care of a sick person to come in for half the day and then take intermittent leave. They just need to be out so that the virus doesn't spread. At least that's the reasoning from the Department of Labor on that. Again, the FAQs by the DOL answer many more questions and is a great resource. So next we're going to talk about working remotely, and this hopefully is much more commonsensical, so we'll try to move through this a little bit more quickly.
Wait, there's
yes.
a question. Whether fear of contracting COVID is legitimate reason for not going to work, could there be a disability claim in there if the employee has a disability related susceptibility to COVID? Oh, wait, I lost it. Like respiratory issues. Yeah, this is Chris Ho. Yes, there could be. And we'll get to that also later in the presentation, hopefully when we don't run out of time. So fear of contracting COVID is not a legitimate reason for not going to work unless you can show the employer has not provided a safe work environment, has violated some of the required safety standards. Again, you put legitimate, so that's good. There could be a disability claim, for example, the request to have a reasonable accommodation of leave, especially if you have a doctor's note and you have a pre-existing condition that makes you more susceptible. And we can go into that in more detail later in the presentation, because that is a very good question and segue that for about 3 slides from now.
Yeah, and then I see another question from Alexandra. And what I think the question is asking is, so if work is reduced because of the shelter in place or stay at home orders, is that a reason, is that an eligible or a reason for taking emergency paid sick leave? And I think the answer is no.
Oh, no, it can. You can use your sick hours, your PTO from the sick.
You can use employer provided leave, but you can't use this federal FFCRA for that reason.
Oh, yes. I'm sorry. I took that as paid sick leave, not the FFCRA. I apologize.
Yeah. So my understanding is if it's like in the Bay Area, we're all supposed to be at home, sheltering in place, and so we may not have the work that we normally would have. That is in and of itself not a qualifying reason for the expanded paid sick leave. The expanded paid sick leave does have language in there if you're isolated or quarantined, which are special terms of art. Those are terms of art in terms of if you yourself have the COVID-19 virus, or if you've been exposed to someone who does, and that's when you need to either isolate or quarantine. So just a shelter-in-place order or stay-at-home order, like in the Bay Area, is not necessarily going to be a qualifying reason to allow someone to take the new expanded paid sick leave. Beth, do you disagree with that, or have
No. I just misunderstood if they were asking about the FFCRA. Sorry. You're good.
Okay. Okay. So we'll jump into remote working. We'll breeze through this. there should really, ideally, if you didn't have one already, you're going to develop a remote working policy or even a remote working agreement that you would sign with employees, but at least in a policy would be good. Here are some tips. The major one I want to point out, which you all experienced employment attorneys would know, is the expense reimbursement. So now that people are mandatorily perhaps using their own cell phone or internet service to perform work for their employer, employers need to provide a reasonable reimbursement for those costs and expenses and other things like printer ink and other things that might be needed to be able to work at home. And so there's no set dollar amount that any court or the labor code or labor commissioner has set out. It just has to be reasonable. And so that, different minds can differ on how that's calculated, which we probably won't get into right now due to time. But you also just want to, the other main bullet point is the last one I want to point out is accommodation. So if you had employees who had accommodations in the workplace, at the work site, be mindful of how you're going to accommodate that at home, or if you can, or those types of issues. Or if they work at home, do you need to help provide a sit-stand desk, for example, or an ergonomic chair that they may not have at home, but they did have in the workplace? These are all issues you've got to think about as employers for that. Here are some bullet points of ideas to put in any working remote policy or agreements. The other big thing, especially for attorneys and law firm employees, is confidentiality. So you definitely want to discuss confidentiality and what should and shouldn't be accessed, what files can or cannot be taken. For your, on a different note, for your non-exempt employees, you're going to need to make sure that they're still recording their time somehow, because they are entitled to overtime, meal and rest breaks, and you want to have those records, and they want to have their entitlements to that as well. And again, I'm breezing through this because of time. This one is more sort of touchy-feely, meaning figure out how you're going to keep your employees engaged. Are you going to have set meeting times? Are you going to have employees on sort of need to be available around the clock or only during normal business hours? How are you going to communicate with them? Monitor employee burnout is essential. There's been many studies, and I think from my own experience now working at home for the last 4 weeks or so, people tend to work more when they're at home, or they're just more connected and with work, but not necessarily with the benefits of working at a work site, meaning the social aspect of it or the emotional support aspect. So monitor employee burnout for sure. And here are some other tips as well. Okay, so once you're in the workplace, this is right now for essential businesses, but once everyone else returns to the workplace, at least right now, the CDC still recommends social distancing. Here are some tips for that. In the Bay Area, the 6 counties and the city of Berkeley have put together a social distancing protocol. Employers in the Bay Area are supposed to, there's a link here for the Contra Costa version, are supposed to post what they're doing for social distancing, give everybody warnings of, don't come in unless you're healthy, and here are the steps we're taking once you do go inside, and stay away from everybody, wear a mask, et cetera, et cetera. And that link on the bottom of this slide has a good sort of checklist, and you can just checklist off those things and post that right on your front door of your office if that's appropriate for your work situation. Okay, Beth.
Oh, sorry, thank you. So I don't know if you all saw that yesterday LA put in place a requirement that you cannot leave your house without a face mask or a covering of some kind. That's something that we should see start to trickle out into most of California. There was discussion about whether or not it's going to be statewide or city county imposed, but that's something that employers should keep in mind if they want their employees to be working for them outside of the work at home, or they're going to start easing some requirements and letting them come outside, is can this workplace actually provide masks? It's not that they have to have their employees bring their own, is can this workplace provide that? And it's something also to keep in mind that some may have the need for accommodations. They may be allergic to certain things. And that's going to be part of the interactive process, something we hadn't seen before. It's just new. And I went to a bank yesterday, and most employees did not have PPEs. They did not have masks. That means the workplace either wasn't providing it or they're choosing not to wear it. But this will start to shift and function. We have to start thinking about things differently. Workplace rights during a pandemic, they don't disappear. During the CDC classification of a pandemic, there are some elements for disability and accommodation that shift a bit, and it is important to keep an eye on the definitions and classifications of CDC and at the EEOC, DFEH to see if they've helped you guide through those. But first we're going, oh, you have the next page. We're going to quickly talk about some things because James has already gone over those and we've discussed them quickly, but you can have the right to a reasonable accommodation of leave for a disability. The first and most common is telecommuting. It is a reasonable accommodation to telecommute. It would be uncommon not to allow for that, and it would have to be a burden for the employer or business necessity to show that you can't. Then the option thereafter would be leave. Again, medical certification is traditional. However, as medical documentation in COVID-19 can be very difficult, the DFEH is, the Department of Fair Employment and Housing, recommending employers waive this requirement and grant a reasonable accommodation until it's time an employee can reasonably obtain documentation. So I've already started to see cases where employers are threatening termination or refusal to engage in the interactive process or provide accommodation because the note is late, or they couldn't get the note, or they didn't believe in the note. And I believe that that is going to create a host of cases if this doesn't work itself out. If the employee asks for accommodation and they say they can't and it goes to a leave, or the employee needs a leave, there is the FAMLA CFRA leave options for them for their own or their family's serious health condition, which is described here. I know all of you have been through a lot of trainings and we've discussed it in bit here. There are many anti-retaliation provisions on the books in California as well as federal. If people exercise their rights to benefits and or protected leaves, and that would be the request for an accommodation to telework, for leave, for medical leave for themselves or their families, to take sick leave, paid family leave, kinder care, even unemployment, state disability, workers' comp, any of those, you cannot retaliate against them. And sadly, we are seeing that already. I understand it's stressful for employers. I understand they're very stressed, but they cannot retaliate against their employees for exercising these rights. Other areas we're seeing retaliation is when an employee is asking, especially the type of employee who's at work right now, asking for a safe work environment. They're asking for PPEs. They're asking for social distancing, like glass between them and a customer or what have you. And they're being told, be quiet, you'll be fired, we're not giving you that. And so lots of drivers, hourly wage workers, and even professionals. We've had several professionals told work and be quiet. And that would be a whistleblower component. We are seeing a dramatic increase in race and national origin discrimination and harassment. Early on, in early January, this started with just basic bias. This happens. One example was on January 30th, the UC Berkeley Health Services posted a Twitter feed and social media feed to their students for common reactions of stress from COVID-19. And one of them was xenophobia, fears about interaction with those who might be from Asia, and guilt about those feelings. This just goes to show you how much people did not realize that they were projecting race and discrimination. Immediately, there was a significant amount of complaints. The post came down, there was an apology, but obviously the harm was there and people were projecting race and national origin discrimination. On March 18th, there's an interaction between the president, not being political, and a PBS NewsHour anchor who questioned about referring to the virus as Kung Fu, which I spelled wrong, I apologize, and the Chinese virus. And these types of comments are not just happening in the media, they are coming out into the workplace. And that is where the employer has to be careful. Due to a dramatic increase in bias and episodes of xenophobia in San Francisco, the Asian Pacific Policy and Planning Council was created, and they created a tracking tool for hate crimes. It's called Stop Hate. In the first 2 weeks of this tracking, they issued a summary on April 3rd. Of the first 2 weeks of reports, they actually had 1,135 complaints in just the first 2 weeks of race and national origin, xenophobia, harassment, discrimination. And in those first 2 weeks, women were twice as likely to be harassed than men. Children and youth report 6.3% of those incidences. Despite shelter in place, the discrimination incidences were high. Due to the shelter in place, some of those incidences were happening in grocery stores, pharmacies, and big box retail stores. 4.6 of those reported incidences of discrimination happened against Asian descent persons on the job. And Asian employees complained of being the subject of derogatory comments, baseless accusations that they had COVID-19, workplace bullying, and even termination because of their race and national origin. So again, race and national origin discrimination harassment is illegal. That's race, national origin, geographic place of origin, ethnic group, or tribal affiliations, and even someone who's associated with someone of a race and national origin, marriage or cohabitation, and that can also be real and perceived. We've even had phone calls from someone who will say, they thought I was Asian, and then they accuse me of having COVID-19, or they thought my wife. So the law is set forth here. It is unlawful to discriminate against someone because of their race and national origin. The incidences have become so egregious and so disturbing that there was a statement issued by the chair of the EEOC, and I've given you the report by the AAPI. Any questions on all of that? It is kind of depressing. But it is important that employers do ensure their employees know of their anti-discrimination and harassment policies, and that employees are aware of the reporting structure if there is an incident in the workplace. Okay. Another component that is happening right now is increase in disability discrimination and harassment, and that is also real and perceived. That is when someone perceives someone as having COVID-19 or having a medical condition that makes them more susceptible. There is an overlap we're seeing between race, national origin, and disability. Like if someone of an Asian descent coughs, we're seeing these things, or if they're sick. But it is important to know that you need to pay attention to the CDC standards, and the EEOC has issued comments and clarification about what can be asked of someone during a pandemic, so that you don't violate their privacy and their rights. It's very important to understand that you still have to accommodate a disability. You still cannot discriminate against someone for asking for accommodation, and you cannot discriminate against them for having a real or perceived disability. Here we've given you the step-by-step instructions. The EEOC has stepped out and given you some examples. What becomes really confusing is in the pandemic, employers do have a duty to create a safe work environment. So it's kind of this push and pull. You have to protect someone's privacy. And so during the pandemic, employers may request information from their employees who say they're reporting that they're feeling ill or call in sick, for example. But what is that information, and how much can you ask? And what do you do with it? You have to still keep it private. It is still their confidential medical information. You cannot violate their privacy. You cannot ask so much information that you would be learning about a confidential medical condition. So for example, you can ask about their symptoms. That is the symptoms the CDC has listed as the current symptoms of the pandemic. But you can't ask, do you have a confidential medical condition, and learn about it. So what are your conditions? What medications are you taking? And we're hearing a lot of people asking very detailed information, just simple, oh, do you have COVID-19? You should not be asking those kind of direct violation of questions, and it's happening a lot. We've gotten a lot of detail here. James gave you an example to walk through, for example, the temperature check. You've already seen on the news, we're checking your temperature before you walk in the workplace or the cafe. So he'll walk you through that.
Yeah, so normally we wouldn't be allowed to take temperature checks for employees. That would be a violation, but the EEOC, the DFEH, the Center, the CDC has all said employers could do it. It's not mandatory by any means, but if you do want to implement, or if your clients want to implement, here are some tips on the bottom. First tip, which isn't listed, is if there is an employee who is trained, have some medical training, not that taking a temperature is all that invasive, but still you would hopefully have someone who's at least trained to do the testing. There are non-invasive ways to do it as well. And you just, obviously you want to still abide by the social distancing rules. So if you have people lined up, make sure they're 6 feet apart, that kind of thing, wearing PPE if possible, and you can take temperatures. Now, realize two things. Some who do have COVID-19 don't have a fever. So a temperature check may or may not, you may not find out those people. Conversely, you only want to do a temperature check when someone isn't on a fever-reducing medication like Tylenol or something like that. So again, there's other issues to think about if you're a firm or any employer that you're talking with wants to do temperature checks. But here's some tips on the bottom.
Right, and one of the things to really keep in mind is that it sounds like it's not invasive, but it becomes evasive if not implemented correctly and smartly. So one of the things we're seeing is the employer is having employees line up, it's 6 feet apart, they think they're doing it very correctly, and they're happy about it, but what happens is they're doing it in a public setting, so then someone's doing their temperature check and everyone's standing there watching. And then they go, oh my goodness, this person's got a high temperature. And then everyone's like, oh shit. And then they start talking about it, they all start asking questions. We now know we're gonna have a problem. They really need to be more careful about the setting and how you do it to try to protect people's privacy.
That's a good point, great point. Okay, so isolating employees. So the guidance out there right now is that, yes, employers have discretion to bar employees for certain reasons. Of course, if the employee, him or herself, is diagnosed and confirmed to have COVID-19, or is suspected and has taken a test and waiting for confirmation, you can also just isolate employees away from the workplace if they have been in close contact with a family member, caregiver, those kinds of things that have a case of COVID-19. If someone has symptoms consistent with COVID-19, we're getting a little into the area that Beth talked about of not being completely stereotypical. But if they are demonstrating these types of symptoms, you could ask them to return home or not come into work, especially right now if they're an essential business. And also if they have if they traveled recently to any hotspot area. Now that is evolving. Different, it used to be, of course, China, Italy, and other places. Now it's much more prevalent in different places. So travel is, there's no real good guidepost, although a good middle ground might be what's bullet pointed there in terms of if they've been out of the country, if they've been on a cruise, if they've been like to New York City or another state or locality that has widespread transmission. That might be a consideration for telling folks not to come back into the office.
James, there's a question of, can you ask an employee to get a free test?
I think you can if they, you can always encourage your employees to go get a test. There's nothing wrong with that. You, again, want to make sure that you're being consistent in terms of you're not just picking on the old people or the Asians or folks who you think might have diabetes or, you know, something like that. You can certainly say that, yes, employees, feel free to go get your own free test, do your own testing before you come in. I think that's fine. I don't think you can make it mandatory, but.
Right. And so I would always caution that James is correct, making sure you're not identifying a person because of any protected classification or association or what have you, but also they have to have a reason. It has to have a reason aligned with any CDC reason for testing. So that's your first window, is if this person has any of the tickers that the CDC lists as a primary reason for being tested, then asking the person to check their biases at the door. How are they asking this person to be tested because of a race, a national origin, a protected class, a disability? Have they violated their privacies in any way? Have they applied this concern with the CDC questioning across the board equally? And they need to make sure to do those two major hurdles. And they need to ensure that they're also keeping this private information separate in their employee file from employee files, and having these conversations in separate private settings.
Great point. So the guidance from the CDC and other health officials is that, you know, folks who have been exposed or who have, folks who have confirmed case or exposure to COVID-19 should be asymptomatic for 14 days before they return. Or if they haven't been confirmed with COVID-19, they're at least symptom-free for at least 24 hours without any like fever reducers or maskers, and, you know, without Tylenol or, you know, ibuprofen, those kinds of things. And like we said before, it is permissible to get a return to work medical fitness for duty type of note, but given the circumstances, it may not be realistic to get that very quickly, but it can certainly be asked. You know, these all change, I think, as we understand, or as the health officials understand more about the virus, but at least right now, this is the guidance. And I see a question.
Yeah, so Andrea's question is, what about an employee who lives with someone who has been exposed? And I think Andrea's question is worded carefully, because exposed is different than confirmed case, such as a nurse, whether married or not. And then the second part of the question is marital status matter? And in this fact pattern, we don't know if the person actually has voluntarily disclosed to the employer that their spouse or their partner, or the person they live with, has been disclosed, and been exposed. An employer cannot ask someone, do you have COVID-19, or does someone you live with have COVID-19? You can't violate their privacies in that way. So that also means you can't violate their privacies in the have you been exposed.
Yeah, I think I'd agree in that it doesn't really matter. The analysis shouldn't be whether they're married to the person who's a nurse. It's more, are you exposed to the person who is a nurse, not what the relationship is. So if an employer is saying, oh, your wife is a nurse, I think that would be problematic. It's more, are you living or exposed to someone who is a nurse, and without regard to the relationship. So I think we're saying the same thing. Terry has asked, for temperature screening, is there like a temperature threshold? So like 100 degrees would be considered a problem. I haven't seen that, that there is any threshold in terms of what would be considered problematic. I just haven't seen that. I don't know, Beth, if you've seen that out there, but or if anyone has.
I have a who has set the temperature at no, unless the CDC specifically states that that temperature across the board is appropriate, that's not appropriate. So that's their own unilateral decision, and that could create problems.
Okay, so I see some folks are saying it's been in the media, and apparently Madera County Public Health Department has set the temperature at 100.4.
Well,
So I think,
if the employer or client is in Madera County, that's one thing. I haven't seen Contra Costa County setting it at that. If they have, I missed it, but I haven't seen anything at the CDC.
yeah, I haven't either. So that's a good point. I would check your local county health organization as well as the CDC, but I haven't seen anything from the CDC. Okay. So if there is a confirmed case of COVID-19 in the workforce, for all the reasons we talked about, ADA confidentiality still applies, but the CDC and our public health leaders agree that employers should at least disclose to certain employee populations that there has been someone in the workplace that has COVID-19. Now, that doesn't mean the employer should say, hey, our employee Beth Mora has COVID-19. Everybody who was near her go away, or get tested. You still have to be very confidential. You don't want to identify the person. And you want to, if there is a notice provided out for anyone, it should be sort of your least, your most discreet group as possible. So, for example, if the person is worked in a specific work room with three other employees, for example, then maybe disclose it just to those three other employees and not the entire plant or the entire office where there really wasn't any interaction. So again, this is very factual based, but there is some guidance in terms of the amount of sort of notice or disclosure you want to provide to others in the workplace. And here are some tips on that as well, in terms of you want to urge employees to be careful of their own health, observe their own symptoms, and to seek medical attention if symptoms do arise, because they're now having perhaps being exposed, more at risk of facing those symptoms. I think we have 10 minutes left. Is that the flashing signal there? Okay, so I'll move on from this slide. But now, if there's an unconfirmed exposure, possible exposure, in other words, there's no confirmed case. Again, there's no one answer that's going to satisfy every situation. It is a employers should carefully consider how to disclose if to disclose. And again, it could be very factually based, and whether or not it's the whole workforce or not should be notified, if at all. The timing, it might be different if it's someone who has been exposed and is waiting for a test result. You might just want to wait that extra 24 hours for the test result. But if the test is not going to be evaluated for 3 weeks, then yes, maybe that's a different analysis than a 24-hour time frame. And you want to also look at the business impact of disclosing, because like we said before, it might mean that the office or the plant or the manufacturing facility, whatever it is, may need to close down, disinfect everything, and it could have a large ripple effect. And so again, employers need to weigh all these types of issues. Travel restrictions. So for business purposes, employers obviously can restrict employee travel. And obviously the most restrictions would be to areas, both foreign and domestic, that are high impact areas of COVID-19. Non-essential day-to-day travel can be restricted, promote social distancing, that kind of thing. But one note, of course, is that we as employers cannot prohibit employee personal travel plans. So what they do on their own time, you can't necessarily prohibit. You can certainly recommend things, that they don't, travel to Italy, for example, or things of that nature, or they don't, visit their relatives in New York. Now, they may still want to, because it's a family thing, even if they try. but you can't necessarily deny that. But you can say, look, if you do, we're going to, and if they're suffering from COVID-19, we're going to quarantine you so you can't come back to work for 14 days. If you can telework, then we'll let you do that. But you can, employers can certainly go and not, you can't restrict or prohibit travel, but you can certainly advise that these are perhaps the potential consequences for your work here at our company. All right, I think we have time for a few questions other than the ones we've already done. I'm not sure if there's a raise your hand feature or if you just want to type your questions out in the chat, or Beth, if you have other, I don't know, I missed the chat. Some other things came in while I was speaking.
I feel like we got them all. Let me, for me to release someone supposed to, at this point, Kristen asks, at this point, how are employers supposed to obtain PPEs? That's a fabulous question. So one of the Governor Newsom's 6-point test, so to speak, to open up the economy, one of them was to make sure that the workplace was safe, including PPEs for their employees. And obviously that would require other employers, businesses to make PPEs. And so it's going to be very hard to get those. And I think that's a great question. Unfortunately, that's a supply and demand problem, and they're just not easily accessible yet. And I think that's going to be something that more senior government officials are going to have to do, and working with businesses to ensure that they're available so other businesses can open. That's part of the plan. There's another question. Chris Mead, any point of view on intermediate E-family leave? Okay, I'm losing him. Where both parents are teleworking, intermittent E-family leave is permitted by employer consent, but if two parents are working from home with small children, neither may be able to work full time. My recommendation is to make the best argument you can. That sounds like you, Chris Mead, but I'm going to let James.
Yeah, I think there is some in one or two of the FAQs from the Department of Labor. I think they do address if both parents. Well, maybe it's if both parents work for the same employer, that might be what's addressed, and not whether both parents who work for different employers but have to take care of their kids. I think you're right, Chris. I think it is the employer with their own employee has to make the best arrangement that they can. But if both employees work for the same employer, then there are more. There's more control you can have, the employer can have.
And Chris Mead, I think your example is a very common issue in Contra Costa County. We have 2 full-time parents and small children. So this is an issue they're facing.
Yeah, that's a good point. So Chris also mentioned that the Department of Labor FAQs ask employers to be flexible. And in many of the FAQs, it actually says that employers and employees should just work it out. They have that line in there that just work it out, communicate, talk, which is actually kind of new for the DFE or for the DOL, in fact, because they usually take a very hard line on these things. So that's a great point. All right. I think I don't see any more chat questions. Oh, here we have one.
With respect to the law profession specifically, do you think we will have jury trials anytime soon? Kristen Bronte, that's a great question. Thanks, Chris.
Thanks, Chris.
I do not think so. I don't know if you were on the Zoom call with the presiding judges last week. But also, one of the things I always suggest you all do, if you don't, is listen to Governor Newsom's press conferences, listen to the Judicial Council's monthly calls, where the Chief Justice calls in, where the presiding judges call in. You get a great sense of what's happening and how they perceive the courts moving forward. They've done emergency orders. They're doing more regularly than month. It's a wonderful way to get a sense of how they want to deal with the technology moving forward. And civil, if you're asking Kristen about just civil trials, we are very low on the totem pole. We are just one step above unlawful detainer. And if they're going to, you know, even traffic court in some ways are going to get more attention than we are, because traffic court generates money for the state and the counties. So in a way, you can expect that we are going to get the least amount of attention over criminal and family law. And so we're going to be very low on the total bowl. And I would suspect that we are going to be the last to get recalendared and the last to get available dates. And one of the things I do in my lobbying efforts is to protect our rights and protect the statutes. And one of the things you're seeing is across the board, they are willing to continue statutes for civil claims, because they're all starting to accept, between the Judicial Council, the Chief Justice, the Governor's Office, that civil claims are going to be last to come back to life. So I think you should accept, unfortunately, that we are going to be the last to get any breath in the courtroom.
And I'll just throw out two more items. One is that, at least in Contra Costa, if you don't know, the presiding judge issued emergency local rules, at least for civil cases. One of the important things that people didn't know about was that everything, basically, including case management conferences, between really now or earlier in April through May 18th are off calendar. It won't show that on open access, but it's true, it's legit. There is an emergency local rule. And if anyone needs it, you can go to the court's website, you can go to the Bar Association's website, or you can email me and I'll send it to you. But they'll be rescheduled by each judge at some point. We don't know when. And to Beth's point, jury trials for civil are going to be low on the totem pole.
Okay, thank you guys very much. I will echo Chris Mead's. You guys are awesome.
Chris cursed.
I won't quote Chris's chat, but I will echo his feelings. And thank you guys very much. I wanted to let all the attendees know that if you did not formally register on the Contra Costa Bar website, I'm not going to know that you were here in a sense, because I use that information to email materials and things afterwards. And I'm considering adding a MCLE credit for this at this point. So if you haven't registered on the bar's website, I know you had to do the Zoom thing. Go to the bar's website and register. There's no cost or anything, but it's our way of it's a record keeping for us, and then we can get you information quickly, including the materials. And the video will be probably posted on our attorney resources website at least early next week. So thank you all again very much, and Beth and James, as usual, awesome. And everybody have a great day.
Thank you.
Thanks, everyone.
End meeting.
Thank you, Anne.
Hey, thanks, James.
Take care.
You too. Bye-bye.